Good afternoon, ladies and gentlemen, and thank you for joining us. The South African Bar Association hosts a speaker on a weekly basis to deal with a legal topic or advocacy-related topic intended to improve the skill set of legal practitioners and thereby improve the quality of legal representation in our courts. This is a core value of our organization. It brings me great pleasure in introducing today's speaker, Louis Podbielski. Louis has a far-reaching background. He has worked as a veterinary hospital and for the Durban's Child Care Centre. He has been a researcher for the University of Durbanville. He was a candidate attorney, a claims handler for an insurance company, and is an excellent negotiator. He was also an English teacher in South Korea. What's important for his address today, Louis spent 10 years at Juta working on various law reports and has read many of judgments for case selections. He has considerable experience in writing fly notes and head notes, compiling case annotations, and redefining subject indexes. During his 4 years at LexisNexis, he was involved with legal data and analytics and in developing various legal tech solutions. Louis now runs his own case law update service, which provides a daily emailer of case law and news, as well as online case indexes, which I am hoping he shall shed further light on this current project of his during today's address. Advocates and legal practitioners would know that when before a judge and asked the crucial question, "What is your authority?" many counsel, appreciatively so, will refer to Louis' head notes on the case, and every time that occurs, Louis is appreciated. Consequently, we are exceptionally grateful for having Louis addressing us today and looking forward to hearing his address on the legal principle derived from 5 currently trending cases. Before I hand it over to Louis, I shall briefly run through a few housekeeping matters. These sessions are recorded, and we appeal to participants to ensure that your microphones are muted and that your video cameras are switched off. Should a participant have a question, simply raise your hand using the Microsoft Teams platform. Alternatively, pose your question within the chat box. During the question and answer session, kindly restrict questions to Louis relative to the topic under discussion and only pose such questions when called upon. Ladies and gentlemen, I now introduce Louis. Over to you, Louis.
Thank you, Ahmed. I'm just going to turn on my slides. Okay. I'm just going to find, sorry, I'm just looking for my Teams.
No problem.
There we go. There we're back again. There's my screen share. Just let me know if you can see the first screen.
I shall do so the moment I am able to see such.
Okay, you should be seeing it now.
Perfectly. So you can just start your slideshow, Louis.
Okay. Great. And is the video obscuring it, or is it okay?
Perfect. We can see.
Okay.
Thank you.
Thank you to the South African Bar Association and to Bart Ford and Ahmed for giving me this opportunity. As you know, I just love case law, so I think it was prudent of you guys to restrict me to 5 cases, because there's just so many interesting cases these days. Many years ago, when I started out as a law reports editor, the courts used to send a limited amount of cases, and some of the judgments actually came in hard copy, in bundles, like months after they were handed down, and then sent by court reporters in the various divisions, who would take their time choosing as well. But these days, the court's email judgments, and the volumes increase substantially compared to the old days, and they get to us much quicker. And it's not just electronic files and channels that have increased the case law. In this beautiful country we have, we've got this unique situation of old Roman Dutch law overlaid with lots and lots of legislation, and then a modern constitution. And obviously that just leads to litigation, and we've got these massive social and economic challenges. Very interesting eviction cases. I actually had one just this morning that I wanted to talk about, but we'll restrict it. And there's all of these politics and tenders and corruption and separation of powers getting tangled up. So we've got so much litigation going on from all topics A to Z. And you know, because I've been at Jutha and at Lexis, I've seen the traditional model of law reporting, where they only report a small percent of cases, about 1 in 10 that they actually get are selected for reporting in the official series. And because of the processes that they go through, you know, impeccable editing and head noting, but they only reach publication 2 or 3 months after handing down. And unfortunately, my sort of senses are it just doesn't cut it anymore. So that's where my product comes in. And at the moment, I'm covering 3 cases a day, and I aim to share them the following day after receiving them from courts. But it's a very hard call because there's just so many interesting cases being handed down on so many areas of the law. Just picking these 5 cases, I very quickly just picked about 10 or 12, and then I had to whittle them down. One area is medical negligence, and you know, that's getting really interesting these days with our health department budgets and these ever-rising claims. So on the 8th of October, our full bench in Johannesburg handed down this one, which was an appeal, M on behalf of L versus the MEC, where a mother claimed damages on behalf of a child who suffered from cerebral palsy. Now I found this one really interesting about expert witnesses. The contested factual issues in this case, they relate to where the child sustained his brain injury, what caused it, and what its consequences were. But there were large areas of agreement between the parties' respective experts in their joint expert minutes, compiled after an examination of all their medical records. However, this case before the trial court was unusual in that on the eve of the trial, the MEC retained a new expert who then took issue with almost every material agreement that the parties' other experts had reached. And then after the other experts had been presented with this, the parties then filed a new joint expert minute that purported to replace all the previous joint minutes. Now, the trial court ended up finding that it had not been established on a balance of probabilities that the MEC's employees had negligently failed to prevent the hypoxic event or the event that caused the child's condition. Now, the full bench of appeal, if we look at para 20, they tell us that it's long been accepted that a fact agreed in a joint expert minute is a fact of which no evidence needs to be tendered at trial. It's considered a fact that a court can and must accept as true. So the new expert's evidence should not have been admitted because it sought impermissibly to undo agreements previously reached by the parties' experts. And in the circumstances of this case, those agreements were binding on the parties and on the trial court. Now, given the importance of expert agreements, their repudiation should be rare. Now, when necessary, it should be motivated on application to the trial court, and that application should be granted on good cause shown. In seeking to show good cause, a party ought, at the very least, to identify the specific agreements sought to be repudiated and the facts to which they relate, to set out clearly and succinctly the new facts sought to be proved, to explain why those facts are so material to the issues at trial that they justify the undoing of the relevant expert agreements, and to demonstrate that the need to introduce those facts overcomes any prejudice caused to the other party by setting aside the expert agreements already reached. So the full court found that in this case, the new expert's evidence should not have been admitted. So the full court then excludes the new expert's evidence and evaluated the claim based on the remaining evidence. The appeal is allowed with costs, and the order of the trial court is set aside and replaced with one declaring that the MEC is liable for 100% of the proven or agreed damages. Really nice case. Like last year, we had some great cases, especially going up at the MEC, that Mayer case, where the SCA was split 3-2 on medical negligence. Love it. So, judges getting involved with very scientific medical stuff. It's fascinating. And our next case is from my home turf. It's KwaZulu-Natal and Maritzburg, McGregor versus Selborne Park Body Corporate on spoliation, which is one of my favorite topics. In this country, we have the most amazing spoliation cases. A couple of years ago, there was a spoliation case about a door that was taken away from a mosque from the mullah and did that amount to spoliation. Very interesting. Mr. McGregor, he owns residential units within the Selborne Park Golf Estate on the KwaZulu-Natal south coast. He doesn't stay there himself, but he leases his units to various tenants, and he does it through the estate's electronic access portal system. Now, the trustees of the estate, they passed a resolution that had the effect that those who were in arrears with their levies would have their access cards deactivated. So the estate had instituted an action in the Durban High Court against Mr. McGregor for outstanding levies, and he was defending that, and the case was still pending. So Mr. McGregor then approached the courts on an urgent basis, seeking the restoration of his access and the reactivation of his access card. And the High Court found against Mr. McGregor, and that as the owner of the units in the estate, he was contractually bound by both the rules of conduct and the management rules of the estate. And the High Court found that the relief that he sought would be in conflict with the conduct rules and the resolution adopted by the trustees of the estate. Now this appeal was really interesting because the bench was split 2-1. Well, yeah, 2-1. And two of the three judges agreed with the High Court and dismissed the appeal. They found that the relationship here was contractual in nature, and it did not avail him of the remedy of spoliation. Now, what they found was that Mr. McGregor enjoys the right to access the portal system by virtue of being an owner, but he had to obtain approval from the body corporate prior to letting out his units to prospective tenants. So actually, he was never in physical control of this portal system. And even if he were despoiled of access, it could not be said to be wrongful in light of the resolution about access and the arrears and levies. So the appeal was dismissed. Now interesting though, and I just love reading dissenting judgments. Our Common Court gives a lot to them. Our Supreme Court of Appeal gives us lots. It's great material to get sort of both sides. And Judge Mngadi dissented, and he would have upheld the appeal. The reasoning was that the right of ownership of an owner in textual title scheme is limited and regulated by the scheme and its rules. And the body corporate, in this dissenting judge's opinion, has no general power to limit the right of owners in the unit except in terms of the rules. And the portal system was installed in the scheme for use by the unit owners to exercise their rights as owners of units in the scheme. And further, that access, which is an incident of ownership, should be protected by spoliation. Now, there's lots that we can pull out of this case, but for me, the key principle was from Eskom Holdings versus Masinda. And here, the nice takeaway for me was, in order to justify spoliation order, the right must be of such a nature that it vests in the person in possession of the property as an incident of their possession. On the other hand, rights that flow from a contractual nexus between the parties are insufficient, as they are purely personal, and a spoliation order in effect would involve performance in proceedings in which a respondent is precluded from disproving the merits of the applicant's claim for possession. Love it. Very nice that the opinions in this one were split. And our next one is a case from the Supreme Court of Appeal, multi-choice support versus Kelvin Electronics. I really like this one too. Kelvin was appointed as an accredited installer for multi-choice equipment, but multi-choice later gave notice of termination of the agency agreement. Now, this led to several applications by Kelvin, and one was successful, and multi-choice was interdicted from preventing Kelvin from performing. And so Kelvin's access to multi-choice systems was restored. Now, multi-choice did further investigations, and they weren't happy with Kelvin's behavior with their equipment and their access. And that led them to issue fresh notices of cancellation and to approach the court for declaratory orders confirming terminations. And then they terminated Kelvin's access to the system again. So Kelvin then went to court and obtained an order declaring multi-choice in contempt of their earlier order. And on the same day, multi-choice delivered an application for leave to appeal the contempt order. And then Kelvin obtained an order directing that the contempt order operate and be executed in full, pending the outcome of the application for leave to appeal of that order. So multi-choice then approached the SCA. Now, the SCA noted that the order of the High Court granting Kelvin an interdict restoring its access to multi-choice systems, pending a review of the decision to terminate the agreements, was the foundation of everything that followed afterwards. So if that order was unsound, then the other orders that followed were also legally unsustainable. Now, the SCA finds that the first order was erroneous because the decision by a contracting party to cancel a contract concluded between two private parties can't form the subject of judicial review. The power of courts to review the lawfulness, reasonableness, and procedural fairness of decisions or actions taken by public bodies. And the cancellation of the agreements by multi-choice had nothing to do with the control of administrative power or the method of such control, judicial review of administrative action. And secondly, the decision by multi-choice to cancel the agency and installer agreements was not administrative action as defined by PAJA, the Promotion of Administrative Justice Act. So the appeals are upheld. Now, what's really interesting, when I posted this case on LinkedIn, we had a comment that I'd like to share, and this is why LinkedIn is so great. There's just so much going on there. So the comment from one of the LinkedIn lawyers was, and in reference to this paragraph here, I'm not certain that paragraph 14 will solidify in our law. While Kelvin's case is nonsense and an abuse of the process, I don't believe under our constitutional system, particularly a right of access to the courts, it will be possible to not develop the common law in vain of reviewing the lawfulness and reasonableness of private parties within a context of privity of contract. Yeah, I really like LinkedIn for the kind of debate we see in the comment section there. Now, next, we have another SCA case, which I particularly enjoyed. It's McGrain versus Cape Royale. Now, in this one, Mr. McGrain concluded an agreement with Cape Royale to purchase a unit in a sectional title development. And he later instituted action seeking specific performance, contending that he had made the requirement payments, yet Cape Royale failed to transfer ownership. The High Court upheld Royale's plea that the agreement was subject to a condition precedent regarding the securing of a mortgage loan, which had not been fulfilled. So the clause held that in the event of the purchaser requiring a mortgage loan to finance the purchase, the sale shall be subject to the condition precedent that the purchaser obtains approval in principle from a recognized financial institution for such a loan within 21 days. But here's the thing, Mr. McGrain had paid the full purchase price with 2 bank transfers. So he contended that the condition precedent did not apply to him because he did not need the mortgage loan. Cape Royale responded that Mr. McGrain must be kept to the immutable consequences of his choice of not deleting the said clause, and further, that there was no sufficient evidence adduced to establish waiver. So the SCA looks at the clause and finds that proper reading reveals that, sorry, I just want to move this, that it's prefixed by the words, in the event of the purchaser requiring a mortgage loan to finance the acquisition of the unit, this sale shall be subject to the condition precedent. And they find that it is self-sufficiently clear that the parties did not expressly provide that the appellant, as a purchaser, was obliged to obtain the mortgage loan. And they find that the clause is not capable of the contrary interpretation that was contended for by the respondents, namely that the appellant was obliged to obtain a loan. The words, in the event of the purchaser requiring a mortgage loan, cannot be wished away and render the respondent's interpretation untenable. So, the condition precedent of obtaining a mortgage loan was for the benefit of the appellant, Mr. McGrain, and only arose if the appellant required finance. And if he did not require any, no obligation was required by this condition, and the condition precedent did not have any force and effect. So the SCA also found that it is not necessarily fatal to the appellant's case that waiver was not expressly pleaded, and that the SCA had more recently held that litigation is not a game, and that Mr. McGrain, from the onset and during trial proceedings, established waiver. He had emphatically indicated that he had paid the deposit and the full price in cash, and that the respondent's representatives knew that he did not require a loan, even before conclusion of the agreement. So the appeal is upheld with costs. Now, our last case, Eskom versus joint venture, the facts were rather complicated, and I'll sum them up as briefly as I can, because there's no need to deep dive into all of that before we get to the useful principles. Eskom and the joint venture, they concluded an engineering construction agreement for 100 kilometers of transmission line for 320 million. Now you can see why there's such hectic litigation around these construction contracts. It's the quantum, and as a result of the delays, the cost of the project escalated to an eye-watering 807 million, and of course disputes arose as to who was to blame. Now, both parties were dissatisfied with the ensuing ruling of the adjudicator, and the matter was referred for arbitration. And that was not satisfactory either. And the High Court reviewed and set aside the arbitral award in respect of 6 of the 13 claims, and it ordered that the 6 be considered afresh by another arbitrator. Now, Eskom appealed, and I found this SCA judgment really useful for party autonomy and the role and powers of an arbitrator. The actual facts and the disputes about what was put before the evidence of the arbitrator and what he had to consider or not, it's very technical and lengthy. Let's have a look here. So what the SCA looks at is the Arbitration Act, and that review and setting aside of arbitral awards is possible where the arbitrator has misconducted himself, committed a gross irregularity, or exceeded his powers, or where the award has been improperly obtained. Now, the court finds in the end that no gross irregularity or exceeding of authority was shown on the part of the arbitrator, and the appeal is upheld. Now this quote I like as a takeaway from this case. Speed, efficiency, flexibility, and finality of the arbitration process are the reasons that parties opt to select their own dispute resolution method. Admission of evidence, which is not strictly necessary or beneficial to resolution of a dispute, detracts from these advantages. However, the rules of natural justice remain applicable. And there's one more that I liked as a takeaway from this one. It's the Constitutional Court approved the principle of party autonomy in arbitration proceedings by holding that Section 34 of the Constitution, which provides for a right to a fair public hearing, did not apply to private arbitrations. And in modern arbitral practice, fairness goes beyond strict observance of the rule of evidence, provided that the procedure adopted is fair to both parties and conforms to the rules of natural justice. And yeah, those are the 5 cases. But really, our law recently, and it seems to be picking up. It's so interesting and dynamic. There's just so many more we could talk about. And as you know, you can always find me on LinkedIn. And yeah, this is my email. You can reach me here too anytime, or by my phone. My phone's on my LinkedIn, which you can find easily as well. So yeah, over to you, Amit. If there's any questions, let me just stop sharing.
Louis, speaking on behalf of the Bar Association, all the participants, as well as those who want your address, I can confidently say that your address was remarkably informative. I have now opened the platform for a brief question and answer session. To those that have a question, simply raise your hand using the Microsoft Teams platform, and when your name is called, simply allow your mic and or video to pose your question directly to Louis. Alternatively, you may type your question in the chat box, and such question shall be put to Louis. I shall initiate the question and answer session with 2 questions. Louis, I'm hoping you would address the first one, and then I'll move to the second one. The first question pertains to your current project, namely Louis' case law. May you kindly shine light on such for both myself and the viewers? Thank you.
Yeah, no, thanks, Ahmed. I spent a really wonderful 10 years at Juta, and you know, there it's puritanical law reports. It's almost monastic. Real focus on selection and legal writing, and their chief editor Gideon Pienaar has been there maybe 30 years now. And then I moved to Lexis, and there it's much more exciting and innovative, and it's all about technology, and it was really exciting. But I've just always had as I alluded to earlier, the slight dissatisfaction with the way the traditional law reports models work. They actually haven't changed since 1828. You know, the way that the cases come in, the way that they're selected, the head note, the fly notes, the case selection, they only go out once a month. The whole process is quite cumbersome, and also I don't agree. The selection criteria, the reportability criteria, they came from an era where it was different. Before there was electronic means, and before we had this very fast pace of law reports. I just come to me now, the Coleman principles. The Coleman principles were the selection criteria. So I've always been yearning to solve those, what I saw were the shortcomings of traditional law reports. So I've made something lean and agile where I'm able to survey all of the latest cases, cherry pick the good ones, put them in an emailer for practitioners, and they get the emailer at 6 o'clock every morning with 3 cases, and I might have to up that actually. I thought 3 in the morning, Shivash and I used to say two cases a day keeps the LPC away, but I've been doing 3, and it's simply not enough. And the other issue I found with cases that I post on LinkedIn is people, they remember seeing the case come in and reading it, but they can't find it again. And they dig around in the inbox and on LinkedIn and they can't find it. So what I've done, the cases that I choose, I put on an online index. And that's another issue with the traditional law reports. Their subject indexes go back decades and decades. So they've got archaic structures in their subject indexes. So the new cases come in and they have to be indexed according to the archaic structure. So I've just cleaned the slate. And I've made a very, very crisp, concise index. And I built it myself. I've learned web design. So as the cases come in, the new cases inform the structure of the index, and it grows organically. And I've had a lot of users give me feedback since we've launched on the 1st of October. So now I'm going to evolve it again based on the feedback. So this thing can just keep growing as the cases come in, and I can, within minutes, I can reconfigure the things under new topic headings. Well, I think the law is evolving, so I need to make a new main heading and new subheadings. I can do that almost immediately, and it reflects live. So yeah, I'm really, really enjoying this journey. And also, the other niggle is that traditional law reports are extremely expensive. So I know now, especially in post-COVID, everyone's battling. So I've made my product 75 Rand a month as a subscription, which I think is affordable. So I would, and because it's electronic, I'm doing the work any day. I'm doing the same work every day. So I would rather have a very low affordable price and have more people be able to access it.
Thank you, Louis. I think, as your slogan says, law is hard work, and you're doing an excellent job at it. Thank you. My second question, Louis, I'm going to refer you to a case which you have not mentioned. However, with your indulgence, I would like your opinion, naturally hoping that you have familiarized yourself with such case. This is the 2021 case dealing with defamation and motion proceedings. This is the case of the NBC Holdings versus Akani Retirement Fund. From my reading of such a case, there was a letter before the High Court whereby the High Court found that the passage in the letter was a material distortion and defamatory. The appeal succeeded, and the order of the High Court was replaced with one dismissing the application. Now, what I deem to be exceptionally interesting is Willis J's discussion on the discretion of a judge in granting relief and the factors to be considered. Few of them are the interpretation of alleged defamatory material, evidence of corruption relevant to defenses of truth and public interest or privilege, and whether an order can be made in motion proceedings where the respondent produces evidence in support of the existence of a defense. Now, Louis, what is your submission in that regard? I'm hoping you have familiarized yourself with that case.
No, absolutely. I actually did summarize and post that. It went out in my emailer. That the thing is, as a law reports editor, I actually choose not to impose any of my views on it. We stay completely impartial. So it's a very different animal from yourself as litigators who have to take a case and then use it for or against or another. So I only just I've noticed there's been a lot of cases about defamation and motion proceedings. There was the Trevor Manuel one. I think Malema, there was also another one. Obviously the courts have something to say about that when there's dispute of fact and trying to get damages in motion proceedings. But I actually don't. I do remember that case and I remember summarizing it, but I don't have an opinion each way. What I do as my job is to read the case and pull out the principles that it brings, and then I represent that as accurately as I can, and I put it out there. And also the disadvantage I face is that I read so many cases every day that I tend to get a goldfish memory.
Thank you so much. Louis, there's a question from Bart Ford. Bart Ford, you can simply unmute your mic and or your video.
Louis, good afternoon. I hope you can hear me.
Yes, yeah.
The first question I want to ask you, Louis, is in the matter, if you wouldn't mind pulling that case up regarding spoliation.
Yes.
Can you indicate to me whether or not the parties approached the court on an urgent basis? Because there is a case that I found called Mangala versus Mangala, where the court held that spoliation is always urgent. And effectively, what I'm just referring to one of the comments in that judgment where the court said it does not follow that because an application is one for spoliation, the matter automatically becomes one of urgency. However, the court then says the applicant must either comply with the rules in a normal way or make out a case for urgency in accordance with Rule 612B.
Yes.
So the question is, if the issue is that I've been in undisturbed in lawful possession and that possession has been disturbed, whether that necessarily can translate into urgency, that's why I'm quite curious as to whether this matter was heard on an urgent basis.
The original High Court application was heard on an urgent basis, yeah. The case that I described was the appeal.
Okay. So that is
It says, the McGregor case, it says at para 5, as a result, the appellant on an urgent basis launched an application on the 20th of May 2019, seeking orders that the estate restore his possession and access to the estates and the units by activating or reactivating. So, no, that's a really interesting point, because that was quite some time ago. Let's see, and this case was heard on the 4th of June 2021. The appeal was heard on the 4th of June 2021, which is obviously quite some time after that urgent application. Yeah, but was that what you wanted to know?
And then the second question,
Yes.
insofar as the question pertaining to the payment or the application of a mortgage bond, I can't remember the name now, the Coleman matter, is it?
Yes, McGrain versus Royal Cape.
Yeah, is the principle not, though, that where parties are required to comply with a contract that they've entered into, that the principle of pacta sunt servanda would apply?
Let me see if they mentioned that. I've just done a search for that in the McGrain case, and it doesn't seem like the court mentioned that pacta sunt servanda principle.
Thanks, Louis. Those are my two questions.
The Supreme Court of Appeal, their summary, what they put out, which is not necessary that we can rely on it. Their researchers might do that, but they seemed to me to do it purely on interpretation of that clause. They did actually mark this. Oh, they did mark it reportable, but it did seem to turn just on a very simple interpretive exercise. In my opinion, they let me just see. They did quote one of the cases. Yeah, it just seemed to me to be an interpretive exercise, and to me it seemed pretty obvious. I was quite surprised that it would get to the Supreme Court of Appeal, because yeah, to me it just, on the face of it, it just seemed so obvious that the clause would not apply to him when he paid cash.
Thank you.
Thank you so much, Louis. Louis, now I'm going to move to the questions in the chat box. Karishma will be handling that. Karishma. You muted, Karishma. Sorry about that.
Hi, Louis. We have a question from Denise. Regarding the SCA multi-choice case you had mentioned, I'm in agreement with Calvin's submission regarding paragraph 14 therein. What is your opinion to Calvin's comment?
Oh, do you mean the reader's comment from the audience? Let me just pull it up. I just want to get that paragraph 14. It was about administrative action and the private contract, the private contractors. Was that it?
Yes, I think it was that one.
Yes. Sorry, I'm just going to call it up now. System's just a bit slow. I've got the case here. Because our reader, I don't want to mention him on the TV. His first name was Paul, but yeah, I would actually. I found that so fascinating, and I'm in agreement with the LinkedIn reader as well. And again, I'm a law reports editor. I'm not actually. I tend just to, as accurately as possible, state what is in the judgment, and I would actually agree with a LinkedIn comment as well that I think review should be possible, because it's a fine line to say that something's state, and then what about Eskom or what about Telkom? Yeah, so I think that paragraph 14, yeah, it could get interesting if we get further cases coming in. Oh, I've just seen a question. No, of course. I'll email Bart and Ahmed the slides, and we'll share them later.
Sorry, Louis, for ease of for the viewers that are going to be watching this at their leisure, can Karishma just read that question out?
Oh, someone wanted us to share the slides.
I'm sending me dead, like picked it.
No, so well, it wasn't a question. It was just, is it possible that Louis could share his presentation slides with us?
Absolutely, I'll do that.
Okay, thank you.
Just on that note, it's always been a contentious thing as a law reporter. If you get a case that really seems to make new law, but you think it's wrong, one has to share it because it's at the High Court and it's been handed down now as law in that division. So one ought to share it. But if your gut's telling you that you think it's wrong, it does put you in a bit of quandary. So yeah, that is just one aspect with law reporting, that and also you can get a judgment that although you think it's highly reportable and interesting, it's written in a way that's not clear, like two paragraphs where you think they're important dictum and they slightly contradict each other, and you don't know what to do with it. You don't know how to summarize it because you're not sure which paragraph to rely on, and the two are slightly at odds with each other. So yeah, law reporting is interesting. I'm certainly not a legal expert. What I am good at is just having a gut sense by now, after having read thousands and thousands of judgments for selection, is just identifying the important bits and articulating the facts as simply as I can, and articulating the law that the case brings. But we do, because we read so many cases, we do develop a sort of a gut instinct when we something just tells us that something doesn't feel right about the case.
Thank you so much, Louis and Karishma. There are many other questions that are posed. However, we are unfortunately experiencing some internet connection issues, and due to such, regrettably, I have now closed the question and answer session. However, before I move to the conclusion, Louis, how does one go about to join Louis' case law for myself and for the viewers?
Oh, you can just go to the website. It's www.louiscaselaw.com. You can join with PayPal, or you can just pop us an email and sign up for the year. Actually, if you sign up for the year, we give you a month off, and it's only $825 for the entire year. Just on that note, I did see, I think it was Bart popped up a question about the reportability. The courts mark most of their cases reportable or not reportable, or of interest to other judges. Now, Jutra and Lexis treat them slightly differently. The Jutra editors tend to follow their own discretion, like completely. They take it as an advisory, but if they think if a case is marked reportable, they'll still apply the selection criteria. So they could very well say it's not reportable and disagree with the marking. Or there are occasions too when the judge, for whatever reason, he marks it not reportable and they decide to report it. The Supreme Court of Appeal, the judges there, I've been to see them over the years many times, and they prefer that law reporters follow their direction. And LexisNexis tends to take more guidance from the markings on the case. But the problem is there's just too much to report. Your flagship law report series, they only have about 330 pages per month. And those pages are very precious. So they simply cannot report everything that comes in that's marked reportable. They just can't. They don't have capacity for it. So they have to apply the selection criteria, which just quickly, it has to make new law. It has to solve a conflict of the law, or it has to interpret a piece of legislation, or maybe render it unconstitutional. It has to be useful out there to the practitioners, and it has to take the law forward or resolve an issue or a conflict in the law.
Thank you so much. Louis, what remains is yet again to sincerely thank you for your illuminating address and for your time. The South African Bar Association is indebted to you. Appreciation to all those that have participated virtually and shall be watching this session at their leisure. These sessions are recorded, and the recordings can be found upon the South African Bar Association website, that being www.rsabar.net. I thank you.
Thank you, Ahmed. Thank you, Bart. Thank you all.